Okay, this is Diesel We the People News, alright? Without prejudice, and or without recourse. Alright, I'm not waiving any of my rights whatsoever. None. Alrighty, video back, we was talking about the judge's name. Now, I'm going to let you know right here. That dirty rotten scoundrel. Okay? This is the judge that is talking about, Williams. Okay? This is the one right here fighting her butt off for her kid. Alright? And if I'm not mistaken, I believe this is the daddy. Alright? And this right here is a very bad, nasty attorney. Okay? And you'll see, and I may pause between here and there, but I'm not going to just show the whole video. I'm just going to listen to it, all that kind of stuff, okay? I just want to kind of give an outlook of, she is going to be spending most of the time talking, and she's going to try to defend her actions. And this one right here is the big evil judge. Like I said on the last video, remember the name of that judge, and this is the judge they was talking about. Okay, we can see if we can get a better picture of her. Let's play a little bit. Oh my goodness.
Leva and Miss Leva Pike, if you would mute yourselves and raise your right.
There you go. There's a little bit better picture. Okay. That's the judge that the other guy was talking about, and I don't know if the guy made this video or not. Is in common with Jeff Morgan, all right. And if you want to do more research on this guy, is Mitchell, Volpe, okay. And he court watches all the time. Some of his film is blacked out too. I don't know why, but that's where it stands right now. All right. So, without further ado, let's get this out of the way and kind of make this look a little bit more professional-like. For no more equipment than I have, I gotta rig around things, alright? Let's proceed forward, y'all.
Hands, please. Miss Leva Pike, would you unmute yourself and raise your right hand, please? Are you frozen?
The one I showed you, her video's frozen at the particular time.
Oh, can you hear me?
I can hear you, but you look to be frozen. Are you frozen?
Your Honor, can you hear me?
I can hear you.
I don't know why I'm headed to the client.
Trying to get everything situated.
Your Honor, I apologize for the technical difficulties.
Okay, that's
I got it fixed.
all right, good. All right, would y'all raise your right hands, please, and be sworn? Do you each solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Yes, ma'am.
All right, thank you.
Now recognize that she just did that under perjury. Alright? I'm just saying. So whatever comes out of her mouth, she is saying it's true in fact. Alright?
All right, Ms. Forum, this is your motion.
Your Honor, before we proceed, I need some procedural clarification as to the motion for this hearing.
What clarification do you need?
In due sequence of motion filing, there is a federal rule in civil procedure as well as in the state of Texas that motions are to be heard in due order of pleadings. There were 5 previous motions filed as well as dates requested before their initial motion to even request a seal. And that was not provided until February. My motions were filed January 22nd at 12:23, 12:38, 12:33, 12:39, and 12:41. I have been in contact with Ms. Lopez discussing the dates of these motions and have agreed to all dates provided by Ms. Lopez. However, she sent me an email saying opposing party refused to collaborate as far as setting a date and time.
Your Honor, if I may?
You may.
Attorney?
I actually have the email from Ms. Lopez here in front of me. And while Ms. Pike is correct, I believe she filed several documents. They were not all motions.
No, ma'am, I just wish to have the motions to be heard.
There were several documents that were filed, and we filed ours as well, which we were able to get set today. On March 25th.
Objection, Your Honor. I was never spoken with by opposing party as to an agreement on a date. I was simply given an email informing me that this hearing would be heard out of sequence, and absolutely no dates or times were provided to me as they were provided to the opposing counsel.
All right, let her finish her statement, please.
Thank you, ma'am. On March 25th, Ms. Lopez.
Let's stop right there. She kind of the judge interrupted her and said let her finish, but she is ejected. She don't have to let her finish to eject. The words she particularly used at that given time, she had every right to eject to it.
Provided dates to Ms. Pike on the dates that her motions could be set. She said that there's not enough time on the docket today to hear multiple motions, and she has the following dates available. April 16th.
Objection, Your Honor. Those dates should have included my motions, which I am happy to do today, or to request a continuance so all of them can be heard in the same day, as is required in the due order of pleadings.
Okay. Let her finish her statement, please.
Yes, ma'am.
And Ms. Lopez provided April 16th at 1:30 and also April 30th at 9:30 a.m. I do not believe that there is any harm to Ms. Pike for my motion to seal to go forward today.
Your Honor, I disagree completely. This does incredible harm to myself as well as to my children. The motions were to strike perjurious filings, and they should be heard first, in accordance with federal rules and civil procedure.
Okay. Let her finish her statement, please. Ms. Forum, I think you're frozen now.
Your Honor, can you hear me again? I apologize for that.
Yes, I can.
As I was saying, I don't believe that any harm comes to Ms. Pike or her case by having my motion to seal heard today, as it has no adverse effect on her pleadings or her ability to have her motions set and heard. In fact, I would say that the harm could come to me and my client and the court staff and the other attorneys involved in this case. Because if the motion to seal is not heard by the court today, then that gives Ms. Pike an additional 2 to 4 weeks to file more documents containing baseless allegations, personal information, and many things that could bring harm to yourself and other judges that have been attached to this case and the attorneys that are involved in it. So I would agree with her that her motions are not set today, but I would ask the court to go forward on the motion that is properly set, which is mine, which is the motion to seal.
In addition, Rule 21 filing and serving of pleading motions, it states that they must state the grounds thereof, stating that it is not harmful to myself or my children. 76A clearly gives strict guidelines as to how to seal a court records. And none of those. Number one, you did not provide a sufficient reason, and this motion should never have even been scheduled due to that. Secondly, it is out of order. Thirdly, your opinion does not supersede the law. I apologize, Ms. Forum. However, I do think that this is incredibly painful to myself as well as my children, because there are instances of perjury as well as instances of documents that were filed that were not legal, which I am attempting to address, and I have not put anything to harm Ms. Wells in any way in any of these documents. Rather, they reflect the actions Nicholas Leyva has taken to harm myself and my children. In addition, this is important to stay open because there are multiple journalists as well as multiple child rights activist organizations who are incredibly interested in this case and have already reviewed most of the files. This is a public...
Okay, so just to catch you guys up, all right? The blonde lady there is doing all the talking. She's representing herself, doing a fabulous job, all right? But she wants the court to keep it open for everybody to watch. She don't want her court thing in secret. It's the whole court itself that wants it secret. Now, why is that, y'all? Why is that? Now, they're going to get in Pacific using excuses. However, the excuses they use is public record anyway. Alright? All you have to do is research it, just like this young lady did herself. So, it's null and void for their reasoning.
Concern, and it should not be sealed.
All right, what I'm going to do is, I want to present Ms. Layton's motion for April 16th at 1:30 if everybody is available.
Yes, ma'am. Are we going to hear all motions to strike or just one at a time? And then are we going to follow with the motion to seal?
We're going to hear all of your motions to strike in order on April 16th at 1:30. I'm going to hear the motion to seal today. That was set for today.
Your Honor, again, according to, I need a procedural clarification. Are the courts in a habit of disregarding these federal rules and civil procedures and doing motions out of order?
I'm not going to address that. We're going to hear it in the order that I set for today. And this motion to seal is set for today. Everybody got proper notice. We're going to hear that today. We're going to hear your motions on April 16th.
Your Honor, what about Rule 21? As far as they must state the grounds thereof, there were no legal grounds to seal my records, nor was 76A applied, which is required in the sealing of all records. There is a list of requirements that must be fulfilled by the attorneys upon sealing records. In addition, it is meant to be an open case where anyone from the public, opposing parties are able to come in and speak on behalf of whether or not they should be sealed. So if we should be moving forward to seal them, they should at least be done under the proper grounds with time for people to present their opinions in a court of law in accordance to 76A.
All right, give me a moment.
Thank you.
I had to say she's freaking awesome of just been a normal everyday person and that studied and researched, did a fabulous job on this. However, you know, the courts are going to do what the courts are going to do. Everybody else has to obey the law, just not the courts or the cops. I guess at this time the judge is doing some research of the things that she brought up and see how she's going to bypass it, of my opinion. Not facts. I'm not an attorney.
I think that gives me guidance on what I have to do and what she has to present. But she may proceed with, Ms. Moore may proceed with her motion at this time.
I think that it gives me guidance. She didn't say anything with the facts. She says she thinks. So she's going on with presumptions.
Honor, with all due respect, what about Rule 21 and the validity of the motion? She presented no reason, lawful reason to seal, nor did she provide any exhibits before this hearing as to why these records should be sealed.
All right, response, Ms. Moore.
Yes, Your Honor. The motion that was filed was properly filed. I did present in the motion that the sealing of...
Objection, Your Honor, it was not properly filed in regards to Rule 21.
All right, excuse me. Miss Leva Pike, you must give her an opportunity to respond. You cannot cut her off every time.
Yes, ma'am.
All right, go ahead, Ms. Forum.
I specifically asked in my motion that the records be sealed because, as she stated many times, this is governed by Rule 76A, which says that if there's a specific, serious, and substantial interest which outweighs the presumption of openness, then the court has the authority to seal the records. Also, I did state in my motion that the sealing of this records would not have an adverse effect on public health or safety or Ms. Pike's case. I think that the arguments that need to be presented today go to the weight of my motion and whether or not the court should grant it.
Your Honor, she did not provide any arguments in the motion, and she's not twisted the language of 76A. It says it can only be sealed if it is to harm the public. Whether or not it could harm the public is not part of the conversation here. It specifically states it has to be a public issue. And the public has a right to speak on it before they are sealed.
All right. Ms. Warner.
A couple things. First of all, I believe that today's motion will be based largely on legal argument. Please excuse me. As evidence in my position is really not necessary because all that I need the court to do is to take judicial notice of the file and then be given an opportunity.
On my behalf, basically, is I don't need a reason. Just give judicial notice. Just kind of ignore her deal.
To point out the things that have been filed with this court that are currently a part of the public record, which I think absolutely pose a specific and serious harm to the people that are named within these documents. Secondly, one thing I did want to point out real quick, I wanted to ask the court how long we have set on April 16th. I do have a setting in a different county at 1:30 on that day, but I could certainly push it back as it's only a deposition. I would just like to know how long you think we'll need on the 16th.
Well, we'll probably need all afternoon. Let me look and see.
While they're doing this, I just want to remind everybody I'm not an attorney, just my opinions.
She's only given you an hour. I've got another case that I have to do a motion to sign temporary orders. That shouldn't take too long, so we'd have to take a break and come back. Let me see what's available on the 30th. On the 30th, we have it pretty clear all day. Are you clear all day on the 30th?
Yes, ma'am, I am clear on the 30th. I actually had a deposition set in San Antonio that day that just got moved.
Is everybody else clear on the 30th?
Yes, ma'am. Yes, ma'am.
All right, we'll move it to the 30th then at, let me see what time she is here. At 9:30, and we'll give it all day.
Thank you, Your Honor.
Okay. All right. All right, Ms. Forum, you may proceed with your motion.
Thank you, Your Honor. I brought this motion to seal the records before the court today, specifically because Ms. Pike has filed several documents, some of which I believe are improperly filed within this case. But many of these documents include allegations that the court, myself, Ms. Newell, Judge Bennett, and Ms. Lopez, and other people connected with this case are participating in child trafficking, that we have committed fraud, that we have taken part in actively trying to harm these children that are the subject of this suit. Ms. Pike, as I'm sure the court knows, for quite some time had absconded with the children, which led my client to getting custody of these kiddos. My biggest concern is that...
Your Honor, I just want to state for the record that that is not true. The final order stated that Nicholas Leyva and I had an issue with our communication, and in order to promote better communication, he wanted to try something new. And there was no fault found with me in a court of law, nor was it found that I absconded with the children, nor broke my mediated settlement in any way, shape, or form.
All right, appropriate at this time, Ms. Leyva. Please wait till it's your turn to talk. All right, go ahead, Ms. Forum. She's frozen.
The lawyer's frozen, and the other one should have said ejection, because it was only her opinion.
What are you waiting on?
That's a quick question for you, Your Honor.
What is it?
I have filed a notice of enforcement before judgment. It's a certified mail notice to the last known address. It came back undeliverable. We don't know where this lady is. What would be our next step?
Publication.
Do publication? of
Yes.
that position? Thank you, Judge.
All right, thank you.
And I believe that Ms. Boren might be having some internet issues, so we could just wait for her to be able to log back on.
All right, I am.
If I had fancy equipment, I would probably fast forward this a little bit. Again, remind everybody, I'm not an attorney. These are only my opinions. And I do know beyond a shadow of a doubt, with past factual evidence, that judges do in fact
All right,
ignore the
Ms.
laws,
Moore.
and attorneys do too.
You'll unmute yourself, please.
Yes, ma'am, I apologize for that. I switched over to the hotspot on my phone instead of my Wi-Fi network, and I believe it's working better. Can you guys hear me?
Yes, we can.
All right, thank you. As I was saying before my computer froze, which I apologize for, there have been allegations of, as I said, court staff, including the judges and attorneys involved in this case, that were involved with fraud and child trafficking and actively engaging in harming these children. In addition, our home addresses are included. And so these allegations, which are baseless and inaccurate and not filed properly, are of public record, and they are joined with our personal home addresses and our residence addresses, email addresses, and things of that nature. I believe that this is set up, well, as Ms. Pike has just said, that she wants to make sure that the public and reporters and things of that nature see these claims and know where to find us at our homes with our children.
Your Honor, I never stated that.
The intent, in my opinion, and certainly if it was not the direct intent, certainly the very grave risk here is that someone will see these allegations and believe that myself or Ms. Newell or yourself or Judge Bennett have actively been hurting children and will take their own steps to make sure that we are, quote unquote, stopped from doing it in the future. I believe it poses a risk not just to us, but to our families. And I believe that that was absolutely the intent of Ms. Pike. But even if it wasn't, it certainly is a substantial risk. And I believe that that absolutely outweighs the presumption of openness in this case. Also, I believe that there was I'm not sure how long it is. I'll be honest, it was just filed the other day. an affidavit that appears to be around 50 pages long. I haven't had a chance to digest it all. I feel confident that it also has information in it that is misleading to the public. I know specifically it alleges that Judge Bennett made a private call to Virginia and asked for a favor. That favor being, quote unquote, the brutal police kidnapping of the children. To have them sit with strangers until picked up by Mary Beth Adcock and trafficked to the state of Texas. Now that's just one little piece that I found just a moment ago. But that clearly insinuates that Judge Bennett is involved in child trafficking and in the brutal treatment of children. Judge Bennett's address appears throughout this file, her home address, specifically on the criminal complaints that were filed by Ms. Pike. I don't know if these were ever filed in a criminal court. I know that they were filed in this family case, which again, I believe is inappropriate. They are not certified and not admissible into evidence, even within a proceeding, much less in the court's file. Again, these criminal complaints list names and addresses and personal information. When you couple these allegations with the information to find the people who are alleged to have perpetrated these allegations, it presents a very serious threat to those people. I will absolutely state to this court, although it's not the purpose of this hearing today, that I have not been involved in child trafficking. I do not abuse children. I have not behaved brutally or encouraged any brutal behavior towards anyone. But I do have a 9-year-old son. And I would prefer that the public in general, especially misinformed by these baseless allegations, not know where to find me, or the judges that I sit in front of, or the colleagues that I practice with. And I believe that that is absolutely a serious and substantial interest that outweighs Ms. Pike's interest in making sure that the whole world believes that everyone involved in this hearing, except for herself, has injured children intentionally. Thank you.
All right. Ms. Blake.
I'll have to go a step further, y'all. Okay? All you have to do is read the 4D child support contract to realize that there's like a due process. They tell you plain out in court you have no constitutional rights, and there is a contract. So there is conflict of interest.
Yes, ma'am. First of all, I want to state that no fault was found with me in the final order, and I had never absconded with my children, and I kept our mediated agreement to the letter. Again, you can look through the records. No fault was found with me by Judge Catterton in any way, shape, or form, and everything that was said was found to be baseless and lies and perjury by Nicholas R. Leyva. And as far as accusing, I've never accused you, Ms. Wells, in any of the documents. You can review them. They are not baseless. They actually are backed by federal law, Texas codes, Texas statutes, as well as backed with evidence through the documentation of the courts. Additionally, I have come to the belief through reading through my records that Ms. Bennett was actually harmed in this case by Miss Lindsay Newell as well as Nicholas Leyva, considering the level of perjury. The affidavit filed was not even notarized. So these claims are not in any way baseless, and they are important to recognize. Additionally, I do not want any harm to come to anyone ever. I do apologize if anyone would insinuate that or think that I have anything more than wanting justice. I simply want justice. I do not want anyone to be harmed. And I do believe 76A does still need to be applied because there are many things in my records that are of public importance. And I would suggest, due to what Ms. Borum just said, and in regards to protection for herself and her son, as well as everyone else's families, that instead we redact all addresses from all the pleadings. And that should take care of Ms. Borum's concerns.
All right. Just for you guys to understand, that is a remedy. All right. So therefore, it should be able to go on public records.
Your Honor, if I may.
All right, Ms. Forum.
Given the nature of the concerns, I don't believe that redacting the documents is going to be an adequate remedy in this case. The reason being because while it is very troubling that my personal information has been put in public record in conjunction, it's also reached the level that the allegations are so egregious that just having my name attached to them could lead someone to come and try to find me. And certainly Judge Bennett. Judge Bennett, I believe, is probably the only person that's mentioned more than Judge Bennett is Ms. Newell. And I have had items delivered to my house, my home. I know that, excuse me, Your Honor, I apologize. And I know that other people connected with this case have as well. And I believe that the allegations will continue. If Ms. Pike believes that these things have happened, then that should be properly tried in your court. But to simply put them out there and to attach our names to them, it goes way beyond defamation, Your Honor. It's a threat. And if she indeed does not want anyone to be harmed and doesn't want to place anyone in danger or their families in danger, then I would argue that I agree with her. I also agree that 76A should be applied. Absolutely. And I think that under 76A, that the court has the authority, and that in this particular case, the only remedy available to apply the protection that I think even Ms. Pike agrees that we need at this point is to seal the records. And again, I don't believe that that poses any damage to her case whatsoever. It simply means that the public in general can't come, potentially at her request, and read through these files and simply believe the things that are in there with our names on them.
Your Honor, everything.
Yeah, ejection. Hitting documents is a good way to commit harm upon me without the people knowing.
I have filed is backed by Texas statutes, federal regulations, and a provision of evidence. I'm sure that you've not had a moment yet to read my request, which the affidavit is attached to. It is incredibly long. However, that is because there's been just this extremely high level of deception throughout my case by Ms. Newell and Ms. Leyva. I believe they perpetrated perjury on Ms. Bennett. I'm not entirely certain.
Objection, Your Honor, to anything that goes before
Your Honor,
higher order. She's getting into things that were.
Back. I'm sorry. Please stop. We're getting feedback and I don't know. Does somebody have a cell phone on near the...
I believe I did, Your Honor, and the objection, which I concur with, was that Ms. Pike is now going back beyond the previous order, and she's testifying as to things that happened prior to the last final order that
Your
was
Honor, if there is perjury before the order, that is still a perjury and it affects the final order. Just because a new final order is void if perjury is found within the case, in accordance with federal guidelines.
All right.
Boom. I agree.
And therefore, the perjury still applies. And Ms. Worm is not denying perjury within the case. She's just simply stating that it should not have any effect as to what is occurring now.
Your Honor, I do have one more quick issue for the court.